number 21, the people of the state of New York versus Jose Delorbe.
Thank you.
Good afternoon, counsel.
Good afternoon. Excuse me. My name is Robin Achinsky. I represent appellant Jose Delorbe. I'd like to request 2 minutes for rebuttal time.
Of course.
Thank you very much. So this case asks whether the DA handing an immigration consequences form to a defendant at arraignment with no record evidence before the court that its contents were ever conveyed to him imposes a preservation requirement when the court fails to give a pecking warning.
When you say there's no record support that it was ever conveyed to him?
Correct, that its
I thought
contents
his
were
counsel
ever
hands
conveyed.
it to him and says right on the record, I'm handing it to him.
Yes, Your Honor. A piece of paper was handed to my client, an immigration consequences form was handed, but there's no record evidence that the contents of that form were ever conveyed to him. We submit that
Well, I
this
don't
is
know what you mean by
insufficient
conveyed,
notice.
because if I give you a piece of paper that says something, it's conveyed. Whether you choose to read it
Well,
is a different story.
Your Honor, I think you have to look at this in the context of how it occurred. It occurred at the arraignment. This form was handed over to the defendant, so the indictment was also given to counsel. The defendant had to plead. He pled not guilty.
But he didn't plead the next day or that day or
No.
even the following week. He pled 7 months later, right?
Yes, Your Honor.
So even if there was a lot going on, you would agree that there was an opportunity for him to ask his lawyer, what does this mean? What is this about? Or ask the judge, or certainly by the time of the plea hearing to say,
No, Your Honor, I would not agree. And the reason is because the circumstances under which this was handed to him did not give him a reasonable opportunity to even know what this was. He wasn't given time to read it. There was no time given in open court. He didn't even acknowledge he got it. He wasn't asked to sign it. It wasn't discussed whatsoever. My client has learning disabilities in reading. We don't know if he did read it. He certainly didn't read it in
Did the
court.
prosecutor in open court announce that he was serving and filing a copy of the immigration consequences and the indictment?
Immigration consequences
And the indictment?
and the indictment. The DA handed the two forms to the lawyer.
They announced in open court that that's what the
He said-
ADA was doing?
Yes, he said, that's what I'm handing, and then the lawyer handed it to, handed the
understand.
immigration to the defendant.
Go ahead,
And the
finish.
defendant then pled not guilty, discovery was discussed, motion practice was discussed, a plea had been made and rejected. The client, he was not asked to acknowledge it, he wasn't given time to read it. As I said, he has disabilities, and he was then, there are
This
3
case-
pages of minutes. All this occurred in a 3-page span, and then he was sent back into the pen, so we don't
Let
even
me
know
ask
if he
you
took it
Casey
with him.
eventually brings a 440 motion, right? Does he ever say, I didn't have an opportunity to ask my lawyer, I couldn't understand it when I read it? Did he ever say anything like that?
The form never came up again, Your Honor. In that 7.5 months, there were several adjournments. Nobody talked
No, but I
about the
think
form.
the judge's question is in his 440 papers, did he raise this issue?
No, he didn't mention the form. The circumstances under which he got this form are almost guaranteed to be circumstances where he's not even going to realize it.
To bring that forth in his 440 motion?
Not if he wasn't really aware of it, not if he ever read it.
Well,
Isn't it on his direct appeal?
Excuse me, Your Honor?
Raising it on a direct appeal?
This is the
Right.
direct
Does he have to
appeal.
raise it in both?
This is the direct appeal and also the
But
appeal
on the
of his
direct
440
appeal,
motion.
you're saying he has a learning disability. Where is that in the record?
It's in the pre-sentence report, Your Honor, which is part of the record. He was then put back into the pens. We don't know if he brought this form with him, and nothing was said about it at his plea. Nothing was said about it
Hey,
at his sentence.
Can I take you back a second here? All right, if you're done answering Judge Garcia's question. The way I understood your argument is there's a twofold argument. First is the generic notice of immigration that was served at arraignment, and it's said that his PECU claim, is that how you say it?
Okay.
Piquet, the Piquet claim wasn't adequately preserved. Secondly, there was an error, you allege there was an error in denial of the 440 motion per Padilla without a hearing and without signing counsel to represent him on the 440. But the core of this, though, is that the notification of your rights must be done by a judge. And is there anything in the record at all that shows that the court discussed the form on the record ever with the defendant, ever discussed whether he read or understood it? Was anything said by the court at all in reference to this to establish the necessary knowledge, intelligence, and voluntariness of any action that he took?
Not at all, Your Honor.
All right, so it's what the court did here, not what he did, because what he did here was clearly insufficient, because he didn't preserve it. So there's not much argument about that. The question is, what did the court do, right? Isn't that what we're talking about here?
Well, we submit that the court has a responsibility under Piquet to make sure that a defendant knows that he will be deported. But we lost this in the appellate division on the preservation issue. And under Williams, which is relied upon by my adversary, that Williams, as the reason why it's not preserved here, Williams was a completely different situation. The issue came up there before the court and was discussed in open court. It was the sentencing issue 4 times. Or the defendant appeared 4 times before the court.
Counsel, just to go to Judge Fahey's point, yes, the Piquet says what it says about the judge's obligation, but Piquet also imposes the standard preservation requirement, right? And Piquet says that if the defendant had no practical opportunity to object. And isn't this case really about, does this form create the practical opportunity to object? So it's not, I don't think there's any dispute the judge didn't do this here, the Piquet admonition, but isn't this case, does the form create a practical opportunity to object? Because Piquet itself, I think the Piquet case, and there were 2, I think, in there, but Piquet lost on preservation.
Yes, Mr. Piquet himself was totally aware at the sentencing. He
Right.
told the
And
court,
this is different.
deport me sooner.
Right.
He clearly knew.
This is it's a different case.
Very
So,
different
you know,
case, Your
That's why
Honor.
we're here. So what's your argument that he gets this form in Spanish and in English in open court? There's a record that he certainly is served with it. I think, as Judge Rivera said, there's a record, the prosecutor saying I served him with the indictment in this document. So why does not that create this opportunity to object?
Your Honor, we need evidence. In order to impose this preservation requirement, you need a practical opportunity, a reasonable opportunity, however you want to describe it, for the defendant to be alerted to the fact that this important issue is
Would it have been
there.
enough if they said, and we're asking the defendant to sign this form?
He was not asked to sign the
I
form.
know that, but I'm asking, would that be enough?
That's certainly, that might be enough. I mean, what we say is that because of the devastating nature of deportation, which Piquet recognized, and the uniquely devastating nature, and Judge
understand
Stein
your
said as much in Suazo as well, the loss is so great as to be unquantifiable. You really have to have notice when you're trying to say that you'll have no preservation.
Are you requiring an admission of knowledge by the defendant in order to require preservation?
Well, Your Honor, we think because of the unique nature of the devastation of deportation, that actual knowledge should be required, but we understand that, but even under the Williams standard, which is the practical opportunity, here where a defendant in a busy arraignment is given some boilerplate form 7.5 months before his
then
plea.
does it matter that the document is coming from the prosecutor and that the document is coming with an indictment? One is supposed to alert you to your rights, the other is charging you with something, so in that way, perhaps you're not aware that these are different things. But
Right, there was so much going on, Your Honor. He was probably completely overwhelmed, and there was nothing on the record in front of the judge, and it should be in front of the judge. This is an obligation of the judge. Piquet put this obligation
So what
on the
is-
judge to
so
assure.
what's the point of handing it to the lawyer, though? We've got defense counsel who has the form too, right?
I don't know. I think he's just handing over all the papers. There was a lot of stuff going on. I don't even know if the defendant was
So
paying
do-
attention. He
so
didn't acknowledge
that-
getting
So there,
anything.
your position is there's not an obligation on the defendant's part to inquire of the lawyer, since the lawyer is handing these documents over to him?
No, Your Honor. There shouldn't be a responsibility on the defendant in this context. I mean, Padilla talked about how these defendants are the least able to represent themselves. Under the Padilla claim, then, maybe we're talking about what the lawyer may have told him, and we can talk about that at a prejudice hearing. But we're talking here about preservation requirement, and we're talking about
Expand.
reasonable, at the least, reasonable notice.
Would this expand how we have looked at reasonable opportunity to raise in the past? It seems to me that, maybe I don't know every case we've addressed that, but at least most of the cases refer to a period of time. So in other words, you're not being indicted, or you're not being, arraigned and then pleading and being sentenced right away. That's the
Your Honor.
easiest case. But now you're talking about something a little bit different, I think, and well, I think a lot different, actually. So
Your Honor, I would argue that this would be the expansion. Every single case that was cited in our briefs, the discussion of what the issue was before the court. It happened at the plea. It happened at the sentence. In some instances, it happened before then. This is the only case where a piece of paper is given 7.5 months before anything happens. He is not thinking about his plea, his trial, or anything. He's given the indictment. The lawyer's probably showing him the indictment, not the form, and saying, are you pleading not guilty? This is not sufficient notice. This notice would be much less than any of the other cases cited in these briefs. I think this is where we would be having the expansion. Thank you.
Counsel?
May it please the Court, Alexander Michaels on behalf of the people. At the outset, on the subject of the practical opportunity, I just want to stress that the entire premise of both defendant's Peke claim and his Padilla claim is that the issue of deportation was of paramount importance to him. So when, at his arraignment on the indictment in this case, he is served on the record in open court with the notice of immigration consequences, that's not something that he's going to ignore. That's not something that he's going to
I
forget
agree with you about that. What I'm wondering, though, is does the court have an independent obligation to ascertain that the plea is knowing, voluntary, and intelligent, and can that only be fulfilled by the court, or can it be fulfilled by the exchange of written forms?
Well, it's important to distinguish between the
But I need you to answer my question.
Yes, the court absolutely has that independent
All right, so
obligation.
did that happen here?
No, the court did not issue a Peke warning in this case, and
So
we're not
let's
suggesting
take it
otherwise.
a step further. Could you hand a series of forms to a defendant at an arraignment and say, we fulfilled our notice requirement on a number of different obligations and at arraignment, and is that good enough? Then the court doesn't have to engage at all in independently verifying at the plea that he understands the effects of his action.
Well, the only form that was handed to him at his arraignment on this indictment
but do you
was
understand
this
what the reason
particular
I
one.
ask is because the logic of what you're saying is that defendant comes up, in charge of the crime, maybe he's bilingual, maybe he's not, maybe he's just Spanish-speaking in this circumstance. He's given a form that has both Spanish and English on it, but he's given a series of forms telling what rights he has, whether he can plead guilty, whether he can call witnesses, series of those things. Doesn't the court still have an independent obligation to verify at a plea later down the road that he understands those rights before he takes the plea?
Yes, but the preservation
And now,
requirement can still
aren't we
apply.
then, I'm sorry, I didn't mean to interrupt you, go ahead.
But the preservation requirement can still apply, and the
I agree with
hypothetical that
that.
you're
I agree with
positing-
that. I agree with that. There are only some where it doesn't. You're totally correct about that. So does the court then here have an independent obligation to make sure that that person understands this very, very serious consequence, particularly after our Suazo decision?
Well, yes, the court has an independent obligation under
So,
Peke
Let me
to
ask this
deliver a
then.
Peke
So
warning.
if it does, under Peke, how is this an expansion? It just seems to me like more of an error than an expansion. It just seems it's kind of a, the failure to preserve it here because of the procedure that was followed. This isn't as much a legal problem as an error that was made in the process.
Well, if I understand what you're saying correctly, It's not, I'm not sure
I
what
don't
you're
view
talking
it
about
as a
when you say
grand expansion,
I
is
guess.
what I'm saying, in terms of rights for defendants. I
Well, it
view it
would be an
more,
expansion in the sense that this court said in Peke and in Pastor subsequently that the preservation requirement applies to Peke claims. And then the crucial consideration for that purpose is whether the defendant had a practical opportunity to raise the issue below.
And so let me go to that and to where you started your argument, which was with the point that this defendant, who has said immigration consequences tremendously important to me, gets a form titled presumably immigration consequences, and would certainly be expected to read that form. So in Peke, the case makes a distinction between Mr. Peke's case and Mr. Diaz's case that seems to me to be based on knowledge. Did they know, and Peke clearly did, Diaz didn't. As I understood the beginning of your argument, you were really saying we can use the form here as evidence that Mr. Delorbe knew.
Yes, our position
You're
is
not
that...
saying he doesn't have to know. You're saying there's record evidence from which we can infer that he did know.
Well, we're saying both of those things. We're saying that there is record evidence from which we can
But that he
clearly
doesn't
infer that
have
he
to
did
know?
know. We're also saying that the crucial issue, and this is what's spelled out in the Williams decision, is that a practical opportunity to learn about the error is all that's required for preservation purposes.
So you're saying if it's possible for him to have learned something, but it's clear on the record he never learned about the deportation consequences, he still has to preserve?
If it were clear on the record that he never learned about them,
Let me
I
ask it a
think...
different way.
Sorry.
If he absolutely did not know about the deportation consequences, did he have a practical opportunity to withdraw his plea?
Not necessarily. And the logic in Williams is actually informative on this subject, because in Williams, the court was saying that he had a practical opportunity to learn, and he, in fact, appeared to have learned it. It was just that there's no opportunity on the record for that actual knowledge to come out. The court was saying that actual knowledge almost never shows up on the record, and that was a very astute observation in that case. So in a sense, it's whether the court can infer from the record that this defendant actually knew. But of course, the court can't look for concrete evidence of actual knowledge because the record normally doesn't have that. So instead, what the court needs to rely on is at least the practical opportunity to learn about the issue. And to return to Judge Fahey's hypothetical, I would note that the service of many different notices on a particular defendant would diminish the practical opportunity for that defendant. If a defendant showed up in an arraignment and the people served the penal law and the CPL on him, of course that defendant would not be in a position to understand all of the rights that he is later going to be able to assert in one way or another. But that's not what happened
Before
here.
all of
understand that
this,
the
the
key-
only typical notice that was served on a defendant was a request for alibi witnesses.
Sorry, I'm not sure I heard that.
I mean, the only other notice that was typically served at arraignment on a defendant back in the day when immigration consequences were still considered collateral was a request for alibi witnesses. What other notices are we talking about?
The record shows that in this case there
I
was
think
only
you were
one
talking,
document.
you were talking about the hypothetical that I put.
Right, I'm
not
just
what
talking about
was
that
served.
hypothetical where there could be a notice, there could be
Speaking of
additional
back
notices.
in the day, this case actually was pre-Peke, right?
Absolutely,
Okay.
yes.
And it seems like it's been a while that this has been percolating before it got up here. Do you have any idea how many pre-Peke cases are still still in the First Department?
My sense is that there are not many of them at this point. I think one of the reasons this one took so long is because it's a consolidated appeal involving the Padilla issue as well, and of course it's getting to this court.
And of course, that's part of the problem because the court didn't know that it had the obligation to inform the defendant, right?
Absolutely, and I
Well,
want
the
to make...
statute existed, correct?
The statute did exist.
Yes, so the judge knew.
But the Peke decision, which obviously did change
No,
practices,
I
was
appreciate
adopted.
that. That's absolutely true.
So yes,
Let me ask you this. Is there anything on the record to clarify whether or not he took the form with him?
the record does not conclusively indicate one
So
way or the other.
let me I'll give you this hypothetical. So he gets the form, he's then returning to the pens as you described, but the form is actually taken from him.
Well, I think
And he
there's,
doesn't have the form.
there's no reason to assume that the form would be taken from him.
No,
The
this is my
counsel handed it.
hypothetical. This is my hypothetical.
Well, if he had, again, assuming the paramount importance of the possibility of deportation here, he receives this form that immediately lays out the possibility of deportation in this case. If he then loses track of the form for whatever reason, he's not going to forget about it. He's not going to ignore it. He's going to talk to his lawyer about it. And if necessary, he's going to raise it with the court below.
So then, it sounds to me like your rule, taken to its logical extension, means that even without a form, if the prosecutor had merely at arraignment said, and there may be immigration consequences, I'm just putting that on the record, that would have been enough. Is that your rule?
That it would depend on the facts of the case.
That's the facts of the case. I just gave it to you. Is that enough under your
If
rule?
that's the only fact, then yes, the defendant would have a practical opportunity to raise the issue.
So the
from that
form
point.
is not even important in this case?
Well, in this case it is, because it's the only
No,
notice of-
because under I just asked you about your rule, and here indeed, the prosecutor did say, I'm serving a copy of the immigration consequences, so you've got some language on the record that under your rule would mean that the defendant has to go, let me ask about that.
Well, the notice spells out more clearly what those consequences are, and thus puts him in a better position to raise any PECA concerns.
Is your
below.
position that it depends on the content of the notice then, that you have to give enough information about the potential consequences?
Well, yes, it definitely needs to provide enough to give the defendant a practical opportunity to raise the issue below. I just want to point out also that in this case, there's an entirely separate basis for concluding that this defendant was aware of the possibility of deportation, which was his 364-day sentence on his predicate felony conviction. Now, the only reason to reach a 364-day sentence is if it's specifically tailored to minimize the possibility of deportation. That's exactly what happened in defendant's predicate violent felony conviction. He must have known, going through those proceedings, that they were targeting that 364-day sentence precisely because of the possibility of deportation. So, in fact, before he even received the notice in this case, it's abundantly clear that he was aware.
Didn't he also make an inconsistent argument that, A, he didn't know about that there were immigration consequences, and on the other hand, he also said that what he was really worried about was getting back in?
Discretionary cancellation of
Discretionary
removal,
cancellation
I
of
think. Yes,
removal,
absolutely.
yeah.
That was in his motion papers, in the 440 motion papers. And yes, those two assertions are flatly at odds with one another. And it's an example of how he really has no hope of showing prejudice in a case like this. Again, because he clearly already knew of the possibility of deportation, and for various other reasons, including that he received a very favorable plea offer. Unless the court has any further questions, I'll ask that you refer.
Thank you, counsel. Counsel?
Your Honor, we are saying that the court has an obligation to ensure not only that the client knows about deportation, but that there's sufficient notice to require preservation as well, that it should be on the record, it should be under the court's supervision, so the court knows here none of that happened. There was no discussion. In terms of his prior case, we don't know what happened with the prior case. We don't know if immigration was discussed with him. That's exactly why you would want a prejudice hearing. And in terms of and Williams, as I said, was very distinct, 4 times discussed in open court, nothing like this. The 440, there were some inconsistent statements. We're talking about a detained pro se defendant. He asked for an attorney. He should have gotten an attorney. The court actually didn't rule on the deficiency prong. It only erroneously ruled on the prejudice prong, where it found that one fingerprint was enough to preclude any reasonable person from going to trial. Judge Fahey, I watched the argument yesterday. I know what you said about fingerprint evidence. The court failed to mention in that case that somebody else had been identified as having committed the crime. That's in the appendix, in the court appearance. One of the court appearances in between. Our client was never identified, and he was arrested far away from this crime, and he asserted his innocence. There was no confession. The pre-sentence report was also part of the record on appeal. And on the 440, the court didn't mention that as well. So on the 440, he did allege sufficient facts. Any inconsistencies could be due to the fact that he's got learning disabilities, he doesn't express himself well. There should have been a hearing on that. But that deficiency prong was not decided. So I just wanted to make that point. And I want to make a really important point. If this court rules today that against us and says that this piece of paper is sufficient to give rise to a preservation requirement, tomorrow, every DA's office across New York State is going to be handing out this form at arraignment, and PECA will effectively be gone.
And why is that a bad thing?
Well, Your Honor, there'll be no more consequences when the court fails to give
Do
a
you think a
pecking order.
judge would look at that and say, you know, the guy got the form, and I know I'm not going to get reversed if I don't do this? Or are we to assume that our trial judges after Peque are thinking that way?
No, Your Honor, they're not
So
thinking that
then
way.
it really would be kind of to deter a judge from doing that, right? That would be almost like a suppression ruling for us.
Well, Your Honor, though, in CPL 22057, when that was in effect, because there was no teeth to that, that's part of what gave rise to Peque, when this court really emphasized the severity of this consequence, the fundamental nature of
And we
this.
imposed on these judges this obligation, which I think we have to assume, this is a pre-Peque case, it wasn't that happened here, although
It
there was a
did not
statute,
happen
but
here, Your
we
Honor.
hadn't made that statement that you're quoting. And so what we would be doing in essence is creating almost a per se rule that the judge has to do this, and if not, the punishment, the punitive result of that, even if there was an opportunity to object, would be that you undo the plea.
Not exactly, Your Honor. What we're saying is that if you're going to do something that's going to result in such a severe penalty to the defendant, because all defendants will then have to preserve this, if you're going to do this, then you should ensure on the record, which would be before the court, that the person has reasonable notice, practical notice, that this is what he's being
And
told.
absent that, it's error.
And that it didn't happen in this case.
Thank you, counsel.
Thank you.